Our next presenter is Professor Amnon Reichman, my colleague from Haifa University Law Faculty, and also from the Minerva Center for the Rule of Law Under Extreme Condition. Amnon is also the head of the Center for Cyber Law and Policy at Haifa. And from the international law perspective, we'll now move to Israeli law. If you remember yesterday, we made the distinction between civil disobedience, conscientious objection. Amnon will talk about conscientious objection in Israeli law.
Thank you very much. So following on Francis' overview and the emphasis on the relation between domestic and international law, I want to take us to the slightly nitty-gritty aspect of the specific question of objection and disobedience with respect to the military service. As has been mentioned, the question of the role of soldiers in these days is central, and it is central both from a legal perspective, but also from a sociological or political perspective. And that is because, of course, as we all know, the state of Israel does not have the luxury of just saying, okay, people will serve or will not serve in the military, but also because that which binds us together as a nation is interwoven with military service. This is Tzva Am. This is we don't have a professional. We're one of the only jurisdictions currently that do not have professional militaries. We have a duty to serve, including in reserve service. I want to say what I'm not going to talk about. I'm not going to talk about what my dear friend and colleague Ziv is going to talk about, and this is the question of unlawful orders. That's a fascinating question. Thank God that Ziv is here to address it, and he's going to do a wonderful job about that. I am going to talk about the question of service as such. Here, and again, I want to draw another distinction. Currently, we do not yet face the true crisis with respect to people resisting the draft, as has been in the United States during the Vietnam War, nor do we face a question of massive disobedience of orders, which is another category, as has been the case during the Lebanon War with respect to some orders that were given. But what we are facing is a question of volunteers, those who volunteer to join the reserve service, withdraw their consent to volunteer. It's a fine line from a legal perspective, and there is also, as we all know, the distinction between those who volunteer and those who have to serve from the perspective of the military is not so important, because from the perspective of the military service, these are reservists. We can count on them. They're organic to the military units, and we don't. The military does not distinguish between this person is a volunteer, this person is under legal duty to serve. The military unit is organic. Nonetheless, from a legal perspective, there is a difference here. So I don't want to talk about the obvious question. I don't want to talk about the obvious point, and that is that people have the right to withdraw their consent to volunteer. I think that seems to me to be trivial. People may volunteer, and to the extent that they reach a conclusion that the conditions under which they volunteer no longer exist, they have a right, maybe even an obligation, to withdraw their consent. And I think that to the extent that indeed the state is changing its regime, its democratic regime, number one, away from a liberal democracy. And number two, it's changing its regime regardless in a manner that does not reflect broad consent or broad political, effective broad political participation, so it doesn't comply with values and it doesn't comply with procedure, I think it's a bit precious to expect people to say, okay, I ignore this and I do not consider whether to withdraw or not my consent to volunteer. I am going to talk about those under a duty to serve in the reserve service. And those under a duty to serve, even if it's not a reserve service. And here we have a case law. We have the case in Israel. We have a statute. So I'm actually going to talk a little bit about the actual law. So under the law, we have a general law that requires people to serve in the military, and there's the General Security Service Law, Statute, or Act, that basically authorizes the Minister of Defense to call or delegate to others, but to call people to serve and also to waive the duty to serve. And here, first of all, we have an interesting distinction between men and women, unfortunately. Under Section 36, the Minister of Defense may exempt men for interesting grounds, such as military necessity or the overall volume of the required forces. So if the Minister of Defense says, we have enough reservists, we don't need you, that's a legitimate reason to waive the duty to serve. Or for reasons that are related to the needs of the education system. And that is in order to allow the minister to say, we need you elsewhere to educate people. Or settlements. We need you to settle the land, so you don't have to serve, you can settle the land instead. Or for family reasons, or from other reasons. That's for men. For women, the Section 39 says a female who has shown, according to the procedure, that reasons of conscience or reasons of family or religious grounds prevent her from serving in the military, it will be exempted. So conscientious objection is stated for females, but not for males. That is a cause for concern, and it has been addressed by the literature in Israel. Nevertheless, the court under Section 36 said other reasons mean conscientious reasons as well. So you have, under Israeli law, and that's a constitutional right, you have a right to object to serve in the military, reserve, or otherwise. However, the court then draws a distinction between the two types of objections, I think, that were referred yesterday, but I want to refer to them again today. One is a statement under which an individual says, I cannot serve for reasons that are unique to myself. I will not be the same individual if I will be forced to do that. If I will look at the mirror, it will not be me. You use the power of the state to crush an essential component of myself, the self as a moral agency. And that is protected under Israeli law. Under that statement, that very same individual may say, I think nobody should serve, but I do not claim this as part of my right, and I leave it to each and every individual to choose. The second position is a position where people say, I am actually not unique. I think that any moral agent under these circumstances should resist and not serve. And I'm going to not just ask for my exemption, I'm going to fight so that all are exempted. So that's a different position, One is called an individual exemption, and the other is called an ideological exemption under the case law. From a perspective of the individual, both are genuine. That is, a person may say, analytically or philosophically, I will not be myself if I don't fight now, so nobody will join the army. I cannot rest. I must act. I must do something. Otherwise, I will not be myself. And so the moral force can be equal in both cases. But, so the court says, as a matter of right, both should be protected. The individual and the collective or the ideological. The individual that says just me, or the collective, ideological, about the us. However, the court says that when you try to balance this right vis-a-vis the public interest, you get a different result. So then the court says there are three reasons why we cannot treat them both the same. And in doing so, the court introduced something that is not germane to the analytical or philosophical approach to objection that I just outlined and that the court refers to. And the court then distinguishes between selective and complete. By selective, the court doesn't say me or us. The court says, is it, you refuse just because of a certain specific reason, contingent reason, or a particular time and place problem that you may have. In other words, I don't want to serve in Lebanon now because this war is illegitimate in Lebanon. I don't want to serve in the West Bank or the occupied territories or Judea and Samaria. This is Bar-Ilan after all, because this is an illegal occupation and don't want to be part of this illegal occupation, etc. That is called selective. General or full or complete is a position whereby I'm not willing to wear the uniforms at all. I cannot hold a gun at all. I cannot be part of this organization at all. And the court says, shifting from the individual and the collective to the selective and complete, the court says selective is not protected under Israeli law in the sense that you have a right, but the right may be infringed upon for reasons that I will outline very briefly now. Whereas if it's a complete, if you cannot serve in the military as such, you have a right, and the Ministry of Defense must exempt you. Of course, there's a question of how you determine whether it's genuine or not. But okay. So the three reasons that the court gives are interesting. The first reason is that the court says, in that sense, it's a question of quantity. There are more people that will opt for selective disobedience, selective objection, than the complete one. So, and therefore, the externalization over the general overall security will be greater if we accept the selective and not the, and will be less so if we accept only the complete objection. And the court also says, it relates also to a sense of discrimination or differential treatment. The more we allow selective, a sense that there is an unequal burden on everybody, a shared burden on everybody to defend the national security will diminish. The sense of a collective will diminish. Okay, so these are reasons that relate directly, utilitarian reasons that just reflect on what it will do to the force itself. The second reason is a more kind of normative reason, where the court says, there is another externalization, and that is that if we allow selective and people will choose the reason for their objection, that which binds us together will be undermined. Not related to national security or something, related to a component of constitutional identity. the very structure of constitutional identity is premised, the very idea of rights is premised on the notion that rights are risk-taking mechanisms. They say to the government, you cannot do that which you think is good for the general public or the general interest because you have to protect rights. It means that we take a risk in the sense that the general interest will not be fulfilled to its full extent. So it's a limit. Rights are limits, but they entail a risk. The risk is conditioned upon the idea that we all bear the risk. The polity bears the risk collectively or in solidarity. And the court says this will break our solidarity. It will break us into certain tribes, collectives, etc. And the third reason is an evidential reason where the court says it will be more difficult to prove whether your selective claim is genuine, whereas when it comes to complete, I cannot serve in the army, it's easier to prove. That's a third reason. We come out of this kind of confused because the court says, as a matter of right, you have a right to say, I cannot be part of something, but when it comes to the actual power, because of the way the court uses the limitation clause, we get this selective versus complete distinction. Now, so there's a lot of criticism about this decision, but that's where the law stands right now. I want to stress, however, in the 1 minute or so that I have left, is that central to the court's analysis is, even though the court doesn't state so specifically, is a requirement, an underlying or undergirding requirement that the conversation or the decision making is done within the premises of substantive legality. What do we mean by substantive legality? It's not just procedural legality. By law, the authoritarian use of the law, regardless of its substantive values or substantive fit with the premises of a liberal democracy, but the military or the state may use its very coercive power to force people to join the military and risk their lives and deny their liberty, etc., on the condition that it is part of a liberal democracy, which means that the laws must reflect values, the underlying values, the basic principles of the state of Israel as a Jewish democracy, and that the procedural requirements are met, that the law is passed in a procedurally adequate way. And thus we're left with the question that when we start to remove one brick at a time, or all the bricks together as they try but in the first instance, but if we remove one brick at a time and undermine or dissolve the commitment to substantive legality, with it, the tension that is embedded in the Sonnenstein case that I just outlined is going to increase, and it's going to reflect on the duty to serve at all, generally, because not just reserves and not just those with that volunteer. Everybody will be faced with a more and more difficult question when it comes to joining a military force that uses violence as part of its rationale, and that denies liberty of those who serve in it, to the extent that the overall legal structure doesn't comply with substantive legality. And this is something that we must consider. I don't have time to talk about related questions outside the military scope, but we can continue the conversation under the Q&A. Thank you.